Hello students, I am Ramakrishna Das, Faculty of Law from National Law University, Odisha. Today I like to discuss about the concept of private defense. In this module, we will include what is meant by private defense, when this defense is available, on what circumstances this defense will not be available, if suppose what is the punishment which is prescribed under law, what is the criminal liability under this concept private defense. So, let us start with the basic aspects of criminal law. As we know, the crime is based on two principles, that is actus reus and mens rea, that we all know all these two concepts. The entire penal code, Indian penal code, is based on these two concepts, that is actus reus and mens rea. That means the every act which is described under the Indian penal code, it directly or indirectly involves the actus reus and mens rea element. But at the same time, if you are discussing about the entire act which is described under the Indian penal code, chapter 4 of the IPC clearly explains some kinds of acts. Section 76 to 106 of IPC explains certain acts which lacks mens rea. Since there is no mens rea, all the acts which is done under section 76 to 106 will not be considered as a crime. So, the acts which is done under section 76 to 106 will be exempted from criminal liability. See, under the general exceptions, as I said, the entire general exceptions springs on the principle that there is no mens rea. Under these general exceptions, we can classify it into excusable and justifiable offences. The first category is where the law excuses certain class of persons even though their acts constitute an offence. For example, act of an insane, infants or intoxicated acts under mistake of fact or by accident. The second category, that is justifiable offence. The second category is where the acts committed though are offences and held to be justifiable under certain circumstances and hence exempted from the provisions of IPC. For example, judicial acts, acts done out of necessity, under duress, with consent, trivial incidents and acts done in private defense. When an individual citizen or his property is faced with a danger and immediate aid from the state machinery which is not readily available, the individual citizen is entitled to protect himself and his property. It also recognizes that the violence which the citizen is defending himself or for his property is entitled to use must not be unduly disproportionate to the injury which is to be averted or which is reasonably apprehended and should not exceed its limits. That is very important. The exercise of right to private defense must never be vindictive or malicious. The right to private defense is based on the cardinal principle that the primary duty of a man is to help himself. Let us discuss about the rationale of the concept of private defense. See, as we know, as per our constitutional provisions, a state is under an obligation to protect life, limb and property of its subjects. However, it is not possible for the state to extend its help to all individuals all the times and in all the cases. In such a situation, individual in pursuit of his basic instinct of self-preservation will be forced to resort to all the possible means at his command to protect himself and his property. The right to private defense originates from the idea that a person has an inherent right to protect himself by effective self-resistance against a lawful aggressor, or no individual expected to run away but to retaliate when his life, limb or property is in jeopardy. It rests upon the general principle that where a crime is endeavoured to be committed by force, it is lawful to repel that force in self-defense. Section, as I said, section 96 to 106 of chapter 4 deals with the private defense. And section 96 to 106 deals a comprehensive legislative framework of right of private defense. All the provisions have to read together to have proper grasp of the scope and limitations of the right of private defense. The entire scheme of private defense, it is based on these four principles. First one is, every person is entitled to protect himself and others against unlawful attack upon their person and property. When its aid can be obtained, it must be resorted to. When its aid cannot be obtained, the individual may do everything that is necessary to protect himself. But the violence used must be in proportion to the injury to be averted and must not be employed for the gratification of vindictive or malicious feelings. These four essentials are very, very important in order to consider whether a particular act is a self-defense or not. Indian law on the subject of private defense is much wider in scope than the Anglo-American legal system. In India, the right of private defense is available not only for the protection of life of the property of a person himself, but also the person and the property of others. But in English law, the main difference between Indian law and English law is one can exercise the right of private defense only in defense of himself and his immediate kindred. Section 96 gives a statutory recognition to the right of private defense. It reads as, nothing is an offence which is done in exercise of right of private defense. But this right is not an absolute right. This right is limited, it is subject to the limitations contained in section 99 to 106. The right under section 96 is basically preventive in nature and not punitive. It is exercised only to repel unlawful aggression and not to punish the aggressor for the offence committed by him. With regard to the right to defense against the property of his own or another person is available only when there is theft, robbery, mischief or criminal trespass or attempt to commit any of the offence. There is one case in Hukum Singh versus State of UP. It was held that the owner of the land has right to use necessary force if the trespassers fails to remove the trespass. And again another question was whether in the case of free fight, whether private defense can be exercised or not. In a case of free fight, both the parties are aggressors and none of them is entitled to claim right of private defense. An appropriate test for determining as to whether a fight is a free fight or not is to see whether the parties voluntarily entered into fight with mutual interest to harm each other. The question who attacked first is immaterial, it is not a question at all. In Vishav versus State of Maharashtra, the court held that in a free fight there is no right of private defense to either party and each one is responsible for his own acts. Now, the right of private defense is not available against lawful acts. In Conver Singh versus Delhi administration, it was held that when a party is exercising a lawful act under law or any other authority, the accused has no right to private defense. Further, the aggressor has no right to private defense, held in Chacko versus State of Kerala also. So, in these two cases, it was held that if a person is doing a lawful act in a lawful manner, then there is no question of private defense. This would be so even if the person exercising the right of private defense has the better of the aggressor, provided he does not exceed the right, because the moment he exceeds it, he commits an offence. Next is unlawful assembly and private defense. When 5 or more persons come together to form an assembly in order to assert their private defense either in respect of their person, body or property, such an assembly cannot be termed as unlawful assembly. The moment when they use unlawful force, they constitute unlawful assembly. In State of Bihar versus Nathu Pandey, the Supreme Court held that the assembly cannot be designated as an unlawful assembly if its object is to defend property by the use of force within the limits prescribed by law. Section 98 says, right of private defense is also available against an offence committed by a person who might not be criminally liable for his act on account of four elements. One is reason of youth, want of maturity of understanding, unsoundness of mind or intoxicating, or misconception on the part of the doer. This section ensures that a person does not lose his right of private defense merely because the opposite party is legally incompetent to commit the offence and is protected because of legal abnormality. The right of private defense is available only against the commission of offences. If the acts of the lunatic or the intoxicated persons or acts done under mistakes are not offences. Under section 98, which categorically stated that who is committing the crime, that is irrelevant. The only essential ingredient under section 98 or under the concept of private defense, that is the person who is committing offence against a person, and such act must be an unlawful act. Section 98 is based on the fact that right of private defense arises from human instinct of self-preservation and not from any supposed criminality of the person who poses danger to body and property. In Munshiram vs. Delhi administration, the court observed that even if an accused does not plead self-defense, it is open to the court to consider such a plea if the same arises from material on record.